You're watching BCTV. We're all about Branford. You're watching BCTV, Branford Government Television, a service of Branford Community Television. This program is brought to you in part through the support of the town of Branford.
So why don't we call this special meeting of the Planning and Zoning Commission to order? It's Thursday, January 8th, 2026, about 6:30. And at this point, we're going to turn it over to our town attorney, Bill Anaskovich. Bill, take us away.
Thanks, Chuck. Several weeks ago, before the holidays, McKeel suggested that, given the fact that we've got some new members and we've got some early plan review submissions and some conversations going on that suggest you're likely going to receive some significant proposals in the next several months. He thought it was a good idea for me to take a minute and just refresh you veterans. This will be too much for you, Chuck. I'm sorry. Um, and maybe help some of the newer members understand the rules, risks, and best practices around ex parte communications. And I tried to sort of create a PowerPoint deck that you can then take. I've also created a one-page checklist for commissioners that I sent to McKeel and that he'll send to you all along with the deck, I think, after the presentation. I'll try to move through this pretty quickly and organize again the commentary around the rules regarding ex parte communications, the risks associated with not following those rules, and then end with some best practices around how to avoid some of those problems. I'm used to, when I teach, I have a clicker. I don't have the clicker tonight, so I'm at a disadvantage. So let me start with why the rules matter. As you all know, when you act on an application, both in the hearing and the decision phase, you are exercising quasi-judicial powers. And so that imposes upon you as a commission member certain rules that are literally taken from the legal and state agency realm. The most important of which indicate that your decisions have to be objective. They have to be based on evidence in the public record and not personal opinion. When the record contains member statements that cross that line, you jeopardize the ability to sustain that decision on appeal. But the most important part of the ex parte communication rules is really about due process. From the common law through Section 181, which we'll talk a little bit about tonight, courts have repeatedly said that the rules prohibiting ex parte communications are about fundamental fairness and the public's confidence in the integrity of your process. And that's super, super important. Start with a simple definition. Ex parte communication is any off-the-record communication about facts, about evidence, about the legal merits or arguments of a pending matter between you as the decision maker and another party, one of the two parties, or any other interested person, without notice to and an opportunity for the other parties to participate or respond. And you can see that the sort of basic definition captures that sort of essential, fundamental aspect of due process. There's a case in which the Supreme Court, the Henderson case, in which the Supreme Court gives, I think, a really good definition of the 4-181 prohibition on ex parte communications in the statutes. It said, long before the advent of 4-181, it had been held that a fundamental requirement of a fair administrative hearing is that one who decides shall be bound in good conscience to consider the evidence and to be guided by that alone to reach his conclusion uninfluenced by extraneous considerations. That, of course, led to the codification of that concept in several laws that shape, if you will, the prohibition. Again, there's no specific statutory ex parte communication law that applies. The rules have grown out of several different provisions. The first is Section 8-3 with respect to the requirements for a public hearing and a decision based on the record. Section 8-7D lays out your hearing procedures and timelines. Again, the fundamental procedural aspect of due process. And then finally, 4-181, which is used by the courts to guide them in deciding these issues as it relates to local zoning boards. These are state agency rules that are the principles of which are applied to local zoning boards of appeal and zoning commissions. The law has 4 parts. I'm going to walk you through sections A, B, C, and D fairly quickly. Try to be as practical as I can in terms of explaining to you what the statutory language means. As you know, statutory language can sometimes be indecipherable, even for attorneys. But section 4-181, which establishes the principles that courts use to guide their decisions about whether or not an ex parte communication occurred and whether or not that therefore supports reversing or remanding a decision based on the violation. The first section says that unless required for the disposition of an ex parte matter authorized by law, what that means is unless we're talking here about items that the commission can take up without a public hearing as a matter of law, every other aspect of what you do is governed by this. And the substance of the rule is that no hearing officer or member of an agency, read commission member, who in a contested case is to render a final decision or to make a proposed final decision, shall communicate directly or indirectly in connection with any issue of fact, with any person or party, or in connection with any issue of law, with any party or the party's representative. So this applies to attorneys who represent or engineers who are agents of an applicant during the hearing process, without notice and opportunity for all parties to participate. Now, what's that mean? Well, what it means is you may not privately communicate about facts with anyone else or legal issues with any party or their lawyer during the pendency of a hearing, unless everyone involved is given notice of that conversation and everyone has a chance to participate in that communication. Yeah. So what this really means is that as decision makers, you cannot hear or seek out new information or arguments off the record. All the information that you do come into possession of has to be shared openly if it could influence the decision. And third, the goal is always fairness. You should always ask yourself, would it be fair? If the roles were reversed, would I want this conversation to be going on, but literally behind my back, ex parte? Yeah, because due process requires the ability of a person to challenge the information. Okay, subsection B. And if you have a question and you want to just stop, I don't have everybody's picture in front of me, so I don't see hands. By all means, interrupt. Subsection B carves out a series of communications that are not prohibited. So let's just jump from the statutory language to what it actually says. What it says is subsection A doesn't prevent commissioners from talking to one another, or commissioners and hearing officers from getting help from agency staff, employees, or advisors. Think, in our case, most often peer review consultants, as long as the people you're communicating with have not themselves received improper ex parte communications. So a member of the commission calls another member of the commission and privately says, hey, you know what? So-and-so just told me X, or I was down at the site and I saw Y. That is an ex parte communication. Just because you're only talking to a fellow commission member doesn't insulate you from the prohibition. So what that means is normal internal discussions are permitted. Staff support is allowed. You can talk to your staff, but staff can't pass along in those conversations one-sided information from a party, right? So, a staff person is equally bound not to be having ex parte conversations with one or the other side of a contested hearing, and then passing information they get from that conversation along to a commission member. That would be an ex parte communication. Subsection C of 4-181 basically applies the rules to parties other than the in this case commission members. So we're talking here about parties, interveners, and others. And you'll see here that the rule is a two-way street. People outside the agency can't privately communicate with decision makers, commission members, or their staff about the case unless everyone's notified and allowed to participate. This includes the parties, the applicant and any opponents, any interveners, other agencies, and anyone who has an interest in the outcome. That gets perilously close to the question of, well, what's an interest? And that brings us into sort of a different area of the law. The interest can be personal as well as financial. It doesn't have to be merely financial. So the best practice, as you'll see in a minute, is just don't have these conversations and try to figure out later whether or not the person is an interested party. As I say, what this means is that the rule is a two-way street. It applies both to you as well as to applicants, neighbors, and anyone with an interest in the decision. The effect here of subsection C is to prevent back channel lobbying, right? Nothing can be sort of presented to a decision maker that isn't put on the record so that the opposing party has a chance to challenge it. Subsection D, finally, speaks to the timing. When does the prohibition start? When does the prohibition close? And here you'll see that the statute takes a broad approach to this. The ex parte communication rules apply from the moment the matter becomes a contested case through and including the date the final decision takes effect. So, for example, if you have a meeting in which you decide there will be a public hearing on X application, even though you don't set the hearing date till the next meeting, I would argue that the ex parte communication prohibition starts at that first meeting. That it doesn't start. The clock doesn't start when the public hearing opens. The minute you have actual knowledge that this is a contested case, best to close it and not have those conversations. At the other end, the rules apply up until the hearing closes. Yeah. And the hearing closes and or the decision is rendered. Some commissions actually vote on the same night that they close a hearing. We don't tend to do that. So if there's a period of time between when the hearing closes and the deliberation and vote occurs, the prohibition applies during that window as well, not just the hearing itself. Okay. All right. So those are the four sort of basic pieces of the statute. Before I sort of move on to some specifics, any questions about that from anybody?
Real quick, you might go into this in a little bit, but Planning and Zoning Commission has their emails and their phone numbers on the town website. So communications that are derived from that, what would be your guidance?
My guidance would be that if you are in the window when the ex parte communication rule applies, any email that you receive, I would not respond to, even by way of acknowledgement. I would disclose the fact on the record at the next opportunity that you received that email. Personally, I think the best practice is forward the email to staff, don't acknowledge it, and at the next meeting, indicate that you received information via an email about the matter, disclose that, and that unless it's presented, it won't be information that we use. Does that make sense?
Yeah, thank you.
Yeah. Okay. So good. Any other questions about that? All right. So can you just bluff it? This is my students ask all the time. Professor, can you just bluff it for me? Okay. First, and you got the cheat sheet too, the checklist. So that's going to be a bluff as well. A commission member, a decision maker should never learn something about the case in private that the parties and the public don't also know. That's just super important. Two, internal discussion is fine, but using those discussion to launder outside information through staff is not. So you can't sneak it in by having a conversation with the staff member in which you say, Joe Smith from down wherever told that's not kosher either. That's gonna get us in trouble. No one gets to whisper in your ear about a decision that has to be made. And once the hearing, as I say, is pending, the no private communication rule is in effect until the decision's final, until you've voted on that. This can be difficult. I understand that. You're volunteers who live in the community in which these applications are being submitted. But I think, as we'll see in a minute, the consequences for violating these rules are pretty significant. Okay, so what's clearly prohibited? And this goes to the question that McKeel just asked. Private emails or texts about the merits of the case, completely prohibited. Just don't do it. Don't acknowledge an email or a phone call to that extent. As I say, disclose it, report it, pass it along to staff. Let the chair decide at the next meeting what to do. Having one-on-one discussions with applicants or opponents, including the quote-unquote neighbors, is a real problem. Don't put yourself in a position during the pendency of a hearing of being somewhere. I mean, obviously, the grocery store is the grocery store, and the post office is the post office. But don't knowingly put yourself in a position where you're going to be exposed to the potential for that kind of one-on-one discussion, at least during the pendency of the hearing. And then post-hearing evidence, which I'll talk a little bit more about at the end, but that's problematic as well. Don't ever accept a document or information that's not been otherwise covered at the hearing. Don't accept that after the hearing and use it as a basis for your decision, because that's a clear a problem under the ex parte rules. Okay, questions about that?
Yes.
Okay.
This is Dan.
Hi, Dan.
What's the difference between allowed internal discussions and not allowed private communications?
If you're having, you mean among members or?
Yeah, within the commission.
Mhm.
That would be
So can Fred call up Joe Vayuso during the pendency of a hearing and have a conversation?
right.
Yeah, they can. The nature of their conversation, however, should be limited to a discussion of the evidence that's been presented at the hearing. They should not be sharing with one another their personal opinions about applicants or applications or right.
Got it.
But they're perfectly free to talk about the evidence that's been presented. Yeah.
Got it. Okay. Understood.
I hope that makes sense. Hope that's clear. Okay. Other questions about what's clearly prohibited? Okay.
Bill, one quick
Oh,
question.
yeah.
I think courts say, your knowledge and you have familiarity with the site and that's, you just have it. And the question could be, Well, I think that's a terrible intersection. I've been there and, in certain times and something, and traffic's a problem and so forth. And someone could say, well, that's part of your knowledge and information. Are you required to disclose that on the record before the deliberations? Or, I mean, I've kind of seen that a few times. Or,
Yeah,
is there, when do you get into that
yeah.
stuff? Oh,
I don't think that I wouldn't, or I would take the position that you're not required to disclose that opinion, uh,
mhm.
to the extent that it hasn't um, biased your decision in the case prior to to hearing the evidence, right? I think then you're in the bias realm. You're not in the ex parte communication realm necessarily, but you're clearly in a prejudgment situation, right? So to the extent that you can't put aside that opinion, I walk my dog there every morning, and that traffic is horrible, and I can't believe we could put another curb cut in there. Well, if you can't put that opinion aside and listen to the evidence and weigh the expert testimony on traffic, um, then you probably shouldn't be seated. You should probably recuse yourself because you prejudged the application.
Uh,
Um,
it's a little bit, into the bias conversation, but beyond personal opinion, what if you are an expert and you can sort of demonstrate through education and experience that you could put something into the record and then the opposing attorney could sort of cross-examine it?
Yeah, to the extent that you want to, and we've had this conversation, Nikhil, so there'll be situations in which we want to qualify you as an expert. Then opinions, come in, but you don't get to unilaterally decide that you're an expert, and I've heard that. It makes me nervous too. Well, I'm an X, and so I know. Well, that's problematic. Again, that's bias. It's not ex parte, right? It's not, it's problematic.
Right,
But
so we're at
yes, if you're
6:52.
qualified, yeah, yeah. So, but that it's good. It's a good question because my next slide is post-hearing exception for staff or experts, right? So, for example, you've got the leading case in this area is a case called Noros, and Blakeman is the most recent case. I'll give you the Blakeman example. You have a proceeding in which fire chief is asked to give a report after the hearing closes, and he submits the report after the hearing closes, and the losing party appeals and argues that that was an ex parte communication because it came in post hearing, and the court held that because the fire chief's report was based on facts and evidence that had been presented in the hearing, that his position as a fire safety expert saved him, if you will, from a violation. Yeah. So, but that exception is very, very narrow, and I would not, I would hesitate to declare yourself an expert after the fact. Again, the court's gonna very much tie its decision to whether or not this evidence is new, because again, the issue is fundamental fairness. Has this information already been presented so that the two parties have a chance to challenge it? Okay, questions on that one? If not, site visits. Commissioners are permitted to visit a site during the pendency of a hearing. However, you must disclose your visit and any observations that you made on the record. Again, on the record so that both parties have a chance to hear it and to challenge it and to question it, but on cross. So you can go, but you've got to disclose, and any observations that you formed based on that visit should be disclosed as well, so that both parties have a chance to respond. If not, then you're making a decision on what the courts have called secret evidence, and you can't do that, right? It's clearly an observation that's objective. You saw something, but since you didn't disclose it, so that the other side could question it or challenge it, then it's secret evidence, and that violates the ex parte rule. Questions about that? All right. So what happens when we violate the rule? Well, the most obvious consequence for violating the rule against ex parte communications is that you risk a court reversing your decision or remanding the commission's decision for a reopened hearing, so that the evidence that came in that was ex parte could be put on the record. That's time. That's embarrassment. And it's a hassle. I personally feel like, more importantly, that when a commission or a commission member engages in ex parte communications, they're really undermining the public confidence in the rule of law. And lots of people like to talk about that, but the reality is, it's in these particular kinds of cases where the public forms its own opinion about whether the process has any integrity. And so I think, while it may be difficult, I think it's super important in a system that claims to be one based on rule of law. Now, having said that, not every mistake will invalidate your decision. We are human. The law is going to balance fairness with practicality, and recognize that human beings make mistakes. And thus, the courts have developed what's called a harmless error doctrine. An error, an ex parte communication, is harmless if it didn't actually harm a party's rights or affect the outcome of a case. Now, you might think, okay, I don't have to be perfect. But even a mistake has consequences, and the consequences are not, no harm, no foul. If an improper ex parte contact occurs, or another procedural mistake occurs, we're talking here just about ex parte context, but this applies, harmless error doctrine applies to all procedural mistakes. The court assumes, and this is what gives lawyers nightmares, or it keeps us up at night, right? The court assumes that it prejudiced the outcome. It simply reaches a legal presumption that it wasn't innocent, it wasn't harmless. It presumes that it prejudiced the outcome, and it's called in the law a rebuttable presumption, because it shifts the burden to the party defending the commission's decision to show that the error wasn't actually harmless, that even with the error, it didn't meaningfully affect the decision. Okay, so I'm going to keep going, but there's a hand up, so I don't know whose hand that is, but it just showed. So
Probably Joe Hayes.
oh, is it Joe? Joe?
It's my guess. I think he's just wanted to.
Oh, he's
get
just
it.
saying he's here. Yeah. Okay.
Yeah.
All right. Okay. Cool. All right. So again, error can be harmless. You can make a mistake, but know that it has a consequence. The consequence is it shifts the burden to the commission, to the party defending the commission's decision. So if we're in the context of an appeal, we or the defendant would have to show that it was actually harmless. And I'm going to use a hypothetical to sort of illustrate that, right? So let's say the commission was holding a public hearing on a special permit and site plan application for a small mixed-use development along West Main Street. You had two public hearings. They went long into the night, as they often do, You had extensive conversation about traffic, drainage, parking. Everything got vetted, and you closed the public hearing after those two hearing nights. 2 weeks later, but before the deliberation meeting begins, one commissioner receives an email from a local resident that states, "I just wanted to remind the commission that the traffic on West Main Street is already terrible during school pickup hours." The email contains, as you can see, no data, no studies, and no new factual information. It is merely an opinion, right? The commissioner doesn't respond, doesn't forward the email, and doesn't mention it on the record. At the next meeting, the commission deliberates and denies the application, citing traffic congestion, inadequate parking, and failure to meet special permit standards. The denial is appealed to Superior Court. Now pay close attention as we move to the next slide, and remember that the commissioner didn't respond, but also didn't forward or mention it on the record. The applicant on appeal argues that the email was an improper ex parte communication received after the hearing closed, and therefore the decision has to be reversed because the process was tainted. The commission concedes, in this case, the commission's lawyer concedes the email should not have been received or even sent, but argues that the error was harmless as it contained no new facts, and the written decision relies exclusively on record evidence, including the applicant's traffic report and testimony from neighbors at the hearing. So I guess my question for you is, who's going to win this appeal? And why? Come on, I really am teaching a class now.
The judge.
No, who's going to win and why? You're the judge.
The applicant.
Why is the applicant going to win, McKeel?
It was not disclosed and therefore it's presumed prejudicial.
Okay. Anybody want to take a contrary position to that? Be my co-counsel?
It was,
Chuck?
yeah, I think that, did the guy even read the email? We didn't even know that. And it's no new evidence. I think you've established that it's harmless. It's cumulative and nothing new. So anyway.
Yeah. No, so I think, oops, sorry. I think I think Chuck's right. If I'm the judge, Fred, I'm ruling that it's a harmless error. But here's why, and I think this is important. First of all, it's definitely an ex parte communication. Okay, definitely ex parte, definitely violated. So that means the burden then shifts, right, to rebut the idea that it was harmless. And I think the fact that it had no new facts in the email, as we learned, works in our favor. By the way, the fact that he didn't disclose that he received it is problematic, right? That he received it and didn't disclose it. That's really what makes it ex parte, right? Now, here's the thing. I think the most important reason the presumption would be rebutted here is that the record is really strong, right? And this is the piece that I think bears on best practices. It's important not to engage in ex parte communications. It is equally, if not more important, to make sure that your record is based on objective evidence that can be sustained on appeal. And I don't know how the court would go if this was a decision that didn't have a strong record, right? I'm not 100%. I'm not 100% sure. Now, of course, you can take that hypothetical and make it a non-harmless error, and I can ask the same question, right? What if the email contained aerial photographs and pictures of flooding and a statement from the person, whoever it was, the neighbor, saying this application will make the drainage worse, right? All the things that we would typically see in an email like that. Let's say the commissioner read the email forwarded it to two other commissioners, didn't place it in the record. Now you have a harmful error, right? Regardless of how strong the record is. But the reality is that I think the point I want to make is there's no substitute for making sure that your record is based on objective evidence, and is very, very strong, because that's important as a general matter, and it's important in rebutting this presumption. Okay. Questions about that? And if not, I'll wrap it up with this slide. Okay, so you want to build a strong record with objective evidence. Okay. In the last 12 years, there have been moments, I will admit, when when statements were made by commission members, that I was horrified by. You've got to withstand the urge to share your personal opinions about about things, especially during a hearing on an application. Make sure that everything you do share is on the record. Disclose any inadvertent contact you have. Don't just assume that because it's a private email to your personal address that no one else will know, right? Because it's never the crime, it's the cover-up. The case law is replete with instances where those types of emails surfaced after the fact. And if you've gotten a communication, or if someone's reached out, or you don't know, ask. You've got an incredibly seasoned attorney as a chair, and where he, wants opinions from me, he always asks. We can get a set of eyes on it that will help, but we can't help if you don't disclose, or you don't ask. Okay, that's what I got.
Yep. Thank you, Bill.
Questions?
Just before we transition, I just want to thank you, though. I know the commission works hard at all this and wants to do right. I'm just looking at certain things that I know are in the hopper, and want to make sure that, as you said, we want a strong record, and we want to make sure that we give the fairness and the confidence that Branford deserves. So.
Thanks, Mikhail.
Okay.
Thanks, Bill.
You got it.
Okay. So this special meeting, I think we can adjourn the special meeting and then open the regular meeting, right?
Correct.
Okay. Okay, is there a motion to adjourn the special meeting?
Chadwick makes that motion.
Motion by Joe Chadwick. Is there a second?
Fred Russo seconds that.
Second by Fred. Any further discussion? All in favor of closing the special meeting? Joe Chadwick.
Chadwick in favor.
Fred Russo.
In favor.
Joe Bayuso. Is Joe here?
Yeah, I'm here.
Okay.
Yeah, I agree to adjourn.
Okay. And Marcy?
Yep.
And Chair also agrees. Okay, so the special meeting is adjourned. So now we can open the regular meeting, our regular meeting on Thursday. Does someone take a break at all, or should we just proceed?
Let's go.
Let's go.
Joe,
Okay.
do I have a question?
Yes, Joe.
I received I got the agenda for the special meeting, and then yesterday I got a revised agenda without the special meeting. It says regular meeting 7 o'clock. That's why I was very confused. That's why it wasn't on. I didn't realize the meeting was still on. The special meeting.
Right. Yeah, Joe, my understanding is that the special meeting was still on, and there was some typos and other things in the revised agenda, and and Michelle was cleaning that up. But the intent wasn't, that meant that the special meeting was now canceled. So anyway, that was.
Well,
but I understand.
Well,
Yeah.
at the top of the thing it says agenda revised, and it went right
Right.
down the line to
Right.
never
Yeah.
meant.
Yeah. This is still the regular meeting agenda. There is the separate, the special meeting agenda. I know it's confusing. Uh, there was no change to that one. So, but,
Oh, I'm
and I
sorry.
know in terms of you could either watch this and Bill's going to send us a cheat sheet. So, I mean, I think, so I think
I'm
we're
just
good on that.
there. I'm sorry.
Yeah.
Just apologize
Yeah.
for not being there.
Sure. No, not a problem, Joe. Understand. With that, then let's open the regular meeting. Our regular meeting of the Branford Planning and Zoning Commission is Thursday, January 8th, 2026. I have about 7:10 p.m. We'll introduce members of the commission and staff. Commission member Joe Chadwick. Joe, are you here?
Joe Chadwick is present.
Thank you, Joe. Commission member Fred Russo. Fred, are you here?
Fred Russo is present.
Commission member Joe Vayuso. Joe, you're here?
Joe Vayuso here.
Commission member Marcy Pelusi. Marcy, are you here?
Present.
Commission member Sharon Hutner. Sharon, you're here?
Sharon Hutner is here.
And Commission member Dave Dyer. Is Dave here?
Yes, Dave is here.
Hey, Dave. Thanks for showing. And our staff this evening is our town planner, McKeel Wackers. McKeel, you're here?
Here.
Our assistant planner, Dan Robinson. Dan, are you here?
Here?
Our clerk recording secretary is Michelle Martin. I believe she's here. And I am the chair, Chuck Andrus. And with that, we'll ask our secretary to read the notice of public hearing. Fred, can you do that?
Yes, I can. Legal notice, Town of Branford. The Planning and Zoning Commission of the Town of Branford, Connecticut hereby gives notice of public hearings to be held on Thursday, January 8th, 2026 at 7 p.m. by remote technology to consider the applications listed below. Information regarding how to participate in the public hearings will be provided on the Commission's meetings agenda that will be posted on the town's website at least 24 hours prior to the meeting. Application number 25-9, special exception and coastal site plan for a 22 unit residential housing development located at 1, 2, 3, 4, 5, 6, 7, 9, 11, 15, 17 Beacon Hill Road. Paul Santa Barbara, care of Beacon Hill Properties, LLC, applicant and owner. At said hearings, all persons will have the right to be heard. Copies are on file in the Planning and Zoning Commission's office at the Planning and Zoning Department, 1019 Main Street, Branford, Connecticut, 06405. Written communications may be sent to the above address or to planning and zoning at branford-ct.gov. Branford Planning and Zoning Commission, C. Andres, chairperson.
Chuck Andrus, Chair. Thank you, Fred. We'll follow our normal format for public hearings, and that is that the applicant will go first, makes its presentation. After that, we turn it over to staff for a summary of a staff report, open up for questions and comments from commissioners. At that point, we're opening up for public comments. And I'll ask McKeel or Dan to review the process for that shortly. But in general, we ask you state your name for the record, name and address for the record, make your comments. Excuse me. After the public portion is done, we allow the applicant to respond to any public comments. There may be further questions, comments by the commission, and we may or may not close the hearing. It's certainly not unusual for a public hearing to go on for more than one session. So with that, McKeel, do you want to review the process? So McKeel or Dan, whoever wants to review the process for public participation.
Thank you, Chair. I'll read it off. It's McKeel Wackers, Town Planner. So public hearing participation instructions, they're on the agenda as well as I pasted them into the chat. But to summarize, if you wish to speak and you're using a computer with a microphone, click raise your hand in the participant window. If you're on the phone, you can press *9 to raise your hand. And the dial-in information is listed on the agenda. If you do not wish to speak, you may submit a comment using the chat feature. We'll monitor the chat as best we can, but speaking is preferred. When you make a comment, please use your name as required by Public Act 22-3. And again, these instructions you can refer to on the agenda if you have to refresh yourself. All right, Chair.
Okay, Mr. Chair. Thank you, McKeel. And with that, we'll turn to item number 1, which is the public hearing item. That is Paul Santa Barbara, care of Beacon Hill Properties, LLC, applicant owner, at 1, 2, 3, 4, 5, 6, 7, 8, 7, 9, no 8, 11, 15, 17 Beacon Hill Road. This is special exception coastal site plan for a 22-unit elderly housing development. Is the applicant ready to proceed?
Yes, Mr. Chair.
You may proceed, Mr. Lee.
Good evening, Mr. Chair, members of the commission. Happy New Year. My name is Tim Lee. I'm an attorney with an address of 107 Montague Street in Branford. I'm here tonight on behalf of Beacon Hill Properties. They are the owners of a number of properties which comprise this application. In total, the size of the parcel is 7.65 acres, and it's located in the R4 zoning district. As was read into the record, we have submitted an application pursuant to section 7.2 of your regulations to allow 22 age-restricted dwelling units, 55 and over, at this property. The dwelling units would be constructed in 7 buildings on that site. The units themselves would range in size from 1,700 square feet to 2,100 square feet. All of the units would have 2 bedrooms and 2.5 bathrooms. They'd also have 2 garage spaces. This property has been before the commission in 2010 and 2011. At that time, the Planning and Zoning Commission approved an open space subdivision consisting of 10 lots. Ultimately, that development was never built out, and my client went back to the drawing board and they recognized that there was a need for this age-restricted housing in Branford. So they redeveloped their concept to propose the plan that is before you tonight. We have received approval from the Inland Wetlands Commission several months ago, and now we're making the application to the Planning and Zoning Commission. If I don't know how the commission works this, if the commission pulls up the plans, but I'm happy to try to run through the site plan with you. And then there are a couple issues that I'd like to address in particular. Most of them have been raised in McKeel's memo, but I'd like to have a discussion regarding some of those issues as well after we run through the site plan.
So I can share. Is that preferred by you?
That's fine. If you can just pull up the original, the site plan.
Okay. Do you want to start here?
Sure, that's great. Thank you. So the property has frontage on Rose Hill Road. The access to the development would be on Rose Hill Road. As you enter the property, there will be a communal mail center where residents would pick up their mail. There also is a pickleball court that has been designed for the project. Obviously, pickleball is a popular sport, especially with those who are 55 and over, and that's the people that would be residing in this development. The development itself has 7 buildings, and within those 7 buildings will be located the 22 units. The property will be served by, common driveway. If you go down the driveway past the pickleball court to the right, there are 2 units. And then if you carry on to the left, you'll come across the other units. And then there's a turnaround cul-de-sac where you can then turn around and exit the property. Relatively simple design. We had been through the Wetlands Commission. As a result of the Wetlands Commission, we made some modifications to the plan. We had a thorough engineering review through the Wetlands Commission. So I think by the time we got to planning and zoning, we had kind of worked out the kinks of the plan. This afternoon, I had uploaded to the town's portal architectural renderings of what these buildings would look like. I'm not a wizard with the portal yet, so I'm not sure if they've made their way to the commission or not, but we thought that might have been of some interest to the commission. The property itself will be served by public water and public sewer, and I bring up the issue of public sewer because when this property was originally proposed for development in 2010, 2011, the applicant had proposed septic system because there's no sewers in that area. Over the course of time, the town has decided that sewers would be appropriate for this area. They've received some grant money to allow sewers to be installed to service this part of town. And as part of this project, my client is going to make a contribution towards the establishment and contribution towards the creation of the sewer system. We have been before the WPCA. We have, I guess, what I term conceptual approval from the WPCA, but we won't get final approval until such time as they actually design the system, and then we'd make our contribution for that, to that. Also today, I'd uploaded a letter that I received from the town engineer in June indicating that the WPCA had agreed to enter into a letter agreement with us, allowing us to tie into the sewer system once it gets established. I had submitted a proposed agreement to the commission's attorney, and we're just waiting for comment back from him. So I had submitted that to show you that we were making good faith efforts with the WPCA in order to get the tie-in. Obviously, this development would be contingent upon the town installing a sewer system in that part of town, and then us, making the sewer connection in that part of town, or pardon, to the new system that was being created.
Attorney Lee, I can show the renderings of the elevations.
Sure. Thank you.
So this is the 3-unit model. So the front of the floor plan. So it's all on OpenGov.
Thank you, McKeel. And just there's a first floor master bedroom, and the units also have a additional second floor bedroom. Each unit will have 2.5 baths.
Mm-hmm.
And I said before, each unit will range between 1,750 square feet to 2,100 square feet, depending on whether they're an end unit or whether they're a middle unit. With regard to the bulk standards under the zoning regulations, we do comply with all of the bulk standards. We are proposing a total of 55 parking spaces. As I mentioned, each unit will have a two-car garage with parking. They'll also have a driveway in front of the garage, which would allow for 2 parking spaces. And then under the regulations, we're required to have a half space for visitors. So under the regulations, we would be required to have a total of 55 spaces. Let me correct myself. We are proposing a total of 98 spaces between the spaces dedicated to the unit and also the 10 community spaces that we're proposing close to where the pickleball court is. I did have an opportunity to review McKeel's report today, and he had raised some questions and some issues, and I don't want to steal his thunder or go out of order, but I'm happy to try to address some of those commissions now, or if you'd prefer to hear from McKeel before I do so.
Why don't you present your understanding and then we'll look. Yeah. Does that work, McKeel?
That's okay.
Yeah.
So the first issue I just want to raise is the issue of open space. Under the age-restricted housing development regulation, the applicant is required to propose 25% of the property as open space. Our property, as it's currently configured, has 7.65 acres of open space, and our plan shows 1.5 acres of open space. So we don't make the 25% of open space. However, as I mentioned earlier, this property was a subject of an open space subdivision back in 2010, 2011. As part of that approval for the open space subdivision, my client had conveyed 2 acres of property to the town as open space. So what we're asking the commission to consider that we've met the open space requirement, because if you take the 1.5 acres that we're proposing as part of this development and add it to the 2 acres that we previously conveyed to the town in 2011 as part of the open space subdivision that was never built, we would meet the 25% requirement. So we're asking the commission to consider whether that prior submission of open space would be compliant with your regulations. That was issue number one. Issue number two was McKeel had asked, and the regulations required for a market study to show that there's a need for age-restricted housing in Branford. I don't think at this point in time anybody seriously disputes the fact that there is a need for age-restricted 55 and over housing in Branford, especially as the baby boomers get older and look to downsize and want to stay in town. However, the regulations do require the submission of such a report. Eric Anderson, a local builder, did provide me with a report, which I had submitted this afternoon. I doubt the commission's had an opportunity to review that report, but I hope the commission would find that that report satisfies the requirements based on Mr. Anderson's experience as a builder in the town. The next question I had, and this is more of a question. Under section 7.2B of the regulations, the applicant is required to show that we're going to offer housing in compliance with the Fair Housing Act, in a particular section dealing with housing for older persons. In his memo, McKeel asked us to provide a narrative showing compliance with the occupancy standards of under section 7.2. I have no problem showing compliance with that section, but I'm not sure what the commission is looking for in that regard. The regulation itself requires that the homeowners association that would be created provide a notice to the zoning enforcement officer on a yearly basis that they are in compliance with the 55 and over age restriction. So like I said, I'm happy to provide whatever the town wants me to provide in the form of a narrative. I was just kind of asking for clarification as to what should be included in that narrative. If it's simply a statement saying we'll comply with the regulation, I'm happy to do that. If it's something more than that, I'm also happy to do that. I'm just not sure what it's looking for, because the way I looked at the regulation, it was kind of something that would happen once the association was created. That being said, we're happy to do that. We talked about the open space requirement. Next issue McKeel had raised was compliance with the lighting fixtures. Do the lighting fixtures comply with the lighting requirements? As part of the application, we did submit a photometric study that shows that the lighting complies. The developer did contact his lighting contractor. The lighting contractor confirmed that all the fixtures on site will be cutoff fixtures. The only exception would be lights that are on the front porch of the units themselves, but those units will have a covering to prevent any light spillage. We addressed the open space issue. And then the last issue he had raised was the issue of compliance with the WPCA. As I discussed earlier, and maybe got ahead of myself with that, the town is bringing sewers to that area. This project is contingent upon the connection to that sewer system. That sewer system is in the process of being developed by the town. We have had preliminary discussions with the WPCA in which they had indicated that they are satisfied conceptually with our desire to tie into the sewer system. We are going to make a financial contribution to tie into the sewer system, but we can't get final WPCA approval until such time as the plan is designed, and then we're allowed to tie our connection into that. So what we would ask, if the commission at some point in time after this application is done is inclined to approve the application, we would ask that you approve it subject to the requirement that we tie into the sewer system. And then when the town proceeds with the development of the sewer system, we'd complete the process with the WPCA. I know I covered a lot of ground in a short period of time, but I wanted to make sure I addressed all the points. If the commission has any questions, I'm here, the developer's here, and I do have a representative of Giuliano Engineering who designed the site plan, and they can maybe address some technical questions if the commission has any.
Thank you, Mr. Lee. Kim, you will review your report?
Yes. So in the staff report that was online, I went through all the regulations. It is a special exception, as well as a coastal site plan review. This is in the R4 district, but it is this is a new application to replace a previously approved 10-lot open space residential development. Attorney Lee had discussed the 2 acres that has already been conveyed to the town of Branford as open space in that prior proposed development. We'll address that in a minute. Here's an area of the site as it exists earlier this year in April. As you can see, the open space subdivision lots have been platted and are recorded with this is the open space property. And this area is what is proposed to be developed for this age-restricted housing. Again, here's just the original approval that was approved by Planning and Zoning in 2011. And then here's the site plan for the proposed development. So there's the open space that the town already owns, and then there's an open space portion that is in the northern western part of the property. You have the 7 buildings, 2 buildings of 4 units, a 2-unit building, and then 4 3-unit buildings, and then a private drive for circulation on the site. As Attorney Lee said, water and sewer is proposed in order for this development to occur and conceptually approved by the WPCA to run water and sewer extension down Rose Hill Road. Reviewed the bulk requirements. Again, they meet the requirements with the exception of how you treat the open space. So that will be a determination by the commission. Before the rest, we went through the special exception criteria listed in 7.2, which is specific to age-restricted housing. I won't go through all of it, but it does hit many of the points that are laid out within that. I'll go specifically at the end with the items that sort of still need to be documented as being compliant or demonstrate compliance. They meet most of the basic standards that are found in Section 6. That it's a building lot, dimension standards, landscaping, parking, outdoor lighting now after review based on the information that is submitted. Landscaping, they do have a landscaping plan. It's in the site plan packet. I did list the number of trees, and you can generally see where they are located, mostly along the road within the complex, but there is significant wetlands plantings that Wetlands Agency has reviewed and approved. which is noted here for how the wetlands is being handled. There are some impacts. Again, that has been reviewed and approved. This is the other landscaping quantities. The parking calculations, as Attorney Lee stated, 55 spaces is required. They are fulfilling that in addition to the providing additional spaces up to 98 in order to accommodate visitors, as well as just they're utilizing the driveway space as additional parking. So it's more flex space, but they certainly meet the standard. Departments have reviewed and commented. In the Wetlands Department just referred us to their inland wetlands approval and the permit that was obtained. The fire marshal reviewed, but it's going to be we'll be reviewing the building construction documents since it is a multifamily townhouse style development. But they, from a standpoint of planning and zoning, that they will allow the planning and zoning to sort of make their decision. Town engineer, WPCA, this is the sort of the one item that I think really needs to, from a staffing level, I want to make sure that the town engineer is essentially signing off and feels comfortable that there's a path forward and a process that will address the extension. It is not a simple project, so I want to make sure that that is adequately considered, and he signs off so that the commission has confidence in that element. The building official will review this, obviously, when it comes to construction documents, if it's approved. There is an issue with the 4-unit townhouse building. There's an accessibility requirement, making sure that there's first floor living. It sounds like they're accommodating that because now I've just have the floor plans, but I haven't been able to see that prior to this. But it was an item that the building official commented on. Went through the special exception criteria. I won't read through all of it. But generally, it's compliant from that standpoint. And here's the 6 items that Attorney Lee went through. The market study was submitted today, so that's very helpful. Draft ownership documents. There's a section 7.2C that talks about that needing to, there's a certain standard that he needs to comply with, so I just want to make sure that is fulfilled. The narratives, what we intend is really how are they going to qualify the occupants, and do we have a confidence similar to when we talk about affordable housing? We just want to know the process so that we are confident the project will be able to fulfill those standards. Open space, demonstrating 25%. Commission needs to make a determination on whether to accept the prior open space that had already been transferred to the town. And then the lighting, I'll review the schematics. And then finally, the WPCA, just making sure that the Planning and Zoning Commission comfortable with the status of the proposed extension of public sewer. It's still at preliminary stages. No agreement has yet to be signed. But we need to, if I can get the town engineer to be comfortable moving forward, then I, from a staff level, I'm comfortable recommending at least draft motions and other information the commission might need to consider. So at this point, I don't have draft motions, but I do feel like we're at a very close point where we can wrap some of these items up. And I'll leave it to the commission on how they want to handle the public hearing, if they want to keep it open, or based on what comments and discussion has happened tonight, whether or not we are in a position to possibly close it. And I will stop sharing. All right, Chairman.
Checking to see. Thank you, Nikhil. Okay, let's go around to see questions, comments from commission members. Joe Chadwick, any comments, thoughts?
No real no substantive comments. I think the arrangement for accepting the prior land grant is absolutely fine as far as making up the 25% for that requirement. I guess the only lingering question is the schedule for construction and occupancy and how that's going to meet the sewer. And at what point, if the sewer does not go forward for some unknown reason, is there capacity on the site for septic?
Thanks, Joe. We'll just run through commission members and the applicant can address some of the issues. Fred, thoughts, questions, comments?
Yeah, my question, it'll be to Attorney Lee, similar to what Joe's asking, whether or not, I know he's not responsible for the sewers themselves being installed, but would he have any idea, some kind of a timetable when the WPA might start the project at least? Is it a 2-year away project, a 3-year away project? It would seem that we'd be premature doing anything on the application if there's no timetable. At least we should at least know what that somewhere where the timetable is. So that would be my question. Does the Attorney Lee know of the timetable that the sewers potentially would be installed?
Thanks, Fred. And Attorney Lee will give you a chance to respond to all these. Joe Biuzzo, any questions or comments?
Yeah. First of all, I think it's a wise decision to change the prior approval to 55 and older. I think it definitely is a need in the town, and it sounds like they're fairly decent sized units, 1,700 to 2,100 square foot units. That's a pretty good size to me, in my thinking, and I think it would be a nice project over there for 55 and older. And again, like Joe and Fred said, I definitely agree that the land that the 2 acres that they submitted already are handed over already, plus the 1 acre to get to 25%, is definitely should be included. The prior 2 acres, and also the points well taken as far as what's the timetable on the town putting in the sewer so this project can be built in a timely fashion. So I think that has to be ironed out pretty, I guess funding and whatever they need has to be approved so they can get that, get a reasonable timetable for that project to go forward. So, but other than that, I'm all for this project, at least what I heard so far. And I agree, a 55 and older would be, I think, a better fit for that area. Thank you.
Thanks, Joe. Marcy?
Hi. I'm just getting a little mired up in the math. If it's 3.5 acres divided by the total, does that equal 45%? Like, are they almost double the requirement? But I can obviously do that math later. And I think that's generous on their part. And my question around the sewer is, everybody's worried about the time, but it seems like the sewer project doesn't go forward without their contribution. And I just, would like confirmation that that's the case, that without a contribution from the developer, that the town wouldn't be able to go forward with putting sewers in. And the current state of the need up there, I might have missed some of the detail on that. The need for sewers. And that's basically it. Thanks.
Great. Chuck in to share. Thank you, Marcy. Sharon, questions, comments?
No, I don't have anything else to add. I just think the comments about the time frame is a really good one. I think we should get some more information about how long that sewers may take. Thanks.
Thanks, Sharon. Dave, any questions, comments? Is Dave here?
He was.
I thought so.
I do not see him.
Okay, maybe we lost Dave. I had three questions, comments from Mr. Lee. One is the new open. I agree with what everyone has said. Is you should get credit for the open space that's already been donated for the unbuilt subdivision. It's basically part of the same development. It's a different development. So yeah, you should be able to add that. But who's going to get title, or who gets the additional open space? And have you, determine who that is? Is it going to be the town as well? And have you determined whether the town would be willing to accept it? So that would be question number one. Question number two is, I know that there's probably some grading and going on in the site. What I didn't know is, do you need a separate 6.8 application, or is it within an exemption? Or I don't know if anyone's looked at that. I just wouldn't want that to fall through or anything, that, whoops, you didn't get an application. And then the third one was more of a nuance. Just you got a pickleball court right as you go in at the beginning, and I've heard, I don't know, just people complain about noise about outdoor pickleball. And I don't know if, what the distance is to the property, or if there's like some screening you might be able to add for the closest neighbor, because I think you abut against some single family developments. Is that likely to be an issue? Because I think it's right as you go in, and it is not too far away from a neighbor. So those are my three questions. So we've thrown a bunch of questions at you, Mr. Lee. Do you want to respond to to some of these now, and then we also want to open up to the public? But yeah.
Sure. And I guess the first issue is the sewer versus the sewer issue. So the first answer is the project doesn't go forward if the sewer system does not get installed by the town. And we have no objection to a condition of approval that our approval is contingent upon getting approval from the WPCA for this project. I do have Doug Anderson online right now. Doug is going to be the developer of the project. Doug has been in contact with the WPCA. He has informed me that the sewer system for that area has been designed, it has been funded, and it's ready to go. Our development, if it gets approved, is making a significant contribution towards the development of that sewer system. So from that perspective, we're asking you to approve it so that we can then tie in and have our contribution to the septic system be part of the town's development of the sewer system in that area. If for some reason the sewer agreement falls apart, or the town decides not to install a sewer system at that area, our project would not be able to be developed. There is not sufficient area on the property to have septic systems for these units. So the project is expressly contingent upon getting approval from the WPCA. Doug, I see you're online. Is there anything you want to add to what I said in terms of the timing?
Just to clarify the sewer, because that's kind of been a whole moving target from the beginning here. So with the town, this system, actually, believe it or not, this was designed, the sewer system was designed to create a sewer district for the Rose Hill Road and Pent Road areas a number of years ago. It was tied into this previously approved 10-lot subdivision, which caused some financial dynamics to make that project not economically viable, given the agreement that they had made with the town to fund substantially all of that sewer system. So the project never got built, went through a number of owners until Paul Santa Barbara currently purchased the property, and we're helping him come up with a development scheme for the property. So one of the issues with the sewer system, it's a pretty involved sewer system. It has a pump station. It has, however, it will service approximately 25 units on Rose Hill Road, and then pick up another 20 units on Pent Road. So this project was kind of like the catalyst to make that sewer project viable for the town. Up until this point, it's just been on ice because the economics of it didn't really make sense because of the density of because of the capital investment required and the density of the existing homes in the area. So by adding these 22 unit homes into the sewer district that will be created only if this project is approved, is kind of like the chicken and the egg scenario, right? So we had to come first before they would create the sewer district to implement this sewer plan. And then this plan will go out to municipal bid, public bid, and installation, through the Rose Hill Road and Pent Road area. And then there will be an assessment across, equally across all the tie-in components. So these 22 units are basically kind of diluting that cost to help that tie-in fee be more attainable for all the homes that exist in that area that are having, chronic septic system issues with their system failures, mostly due to high water, ledge, and things of that nature. So this has been a 2-year process to try and come up with a method to not only create the sewer district, but also create a project that was economically viable to develop on this parcel where the 10 lots weren't. So that's kind of how we are here today with the project we are in front of you with.
Thank you, Mr. Wilson. Let me continue, Mr. Lee.
Sure. With regard to your question as to who gets the open space, we have not had any discussions with anybody about the open space. The town had, in 2010, the town was the recipient of that open space. So in this case, we'd go back to the town to ask them if they were interested in acquiring this open space as well. If not, there's always a land trust, or the last option would be to create the homeowners association who would keep the property as open space. With regard to the grading question under 6.8 of the regulations, I don't have an answer to that specific question. I do have somebody from Giuliano Associates who's on the line today, but in all fairness to him, he is a replacement for somebody else. So I don't know if he's able to answer that question or not. I don't want to put him on the spot, but that's something we can, unless he knows the answer. But that's something I can get an answer for you on that question. Then with regard to the pickleball, I appreciate the concern about pickleball being allowed. I've heard the same complaints. If the commission thinks that screening is appropriate, we're happy to throw some screening up there. Obviously, we're willing to agree to some time restrictions too. You wouldn't want to play pickleball after a certain time, or either start too early in the morning or finish too late at night. So if there's a time frame the commission thinks is appropriate to restrict the pickleball, we're happy to do that. 8 a.m. to 8 p.m., whatever the commission thinks is appropriate, or later if you think it's later is appropriate.
Okay. Thank you, Mr. Lee. Are there any other questions, comments from commission members or staff before we open?
Chair, this is McKeel Ackers, town planner. I will want to respond on the 6.8.
Yes.
It's required is the short answer. The longer answer is, given there was a previous approval, my assumption is that there was a previous 6.8 on this property, and I was looking to see if I can do a modification to that existing one. But again, I was not able to get that taken care of, and because I was trying to navigate the sewer issue before I even got to getting these comments put together. But that would have to be addressed as well before we make any decisions.
Thank you, McKeel. Okay, so at this point, any other questions, comments? Let's go ahead and see if there's any public comments. Does any member of the public wish to comment on this item? And McKeel or Dan, do you see anyone? Any hands raised?
I do not see hands raised.
Just a reminder that to raise your hand, you can click on the heart the React button. And then from that menu, there's just a raise hand button. So that
Okay.
is a way to flag that you'd like to speak. If not, you could just unmute, announce your name.
Okay. Chuck Anderson, it doesn't look like there's any member of the public for this. Is that correct? No one sees anyone?
Correct.
Okay. Okay. My sense is that we should continue this public hearing. There are a number of items that came up. First, there were some new items that were submitted just tonight, the architectural plans, the report, but also it appears like, you need to find out who the town's willing, to accept the open space. And if not, maybe the land trust, or that'd be my preference rather than the homeowner association, if you can get one of those two. And then it looks like you need a 6.8 as well. So,
Yep, I think that makes sense.
yeah. So, question is, when should we continue it to? Because I don't think you're going to get your 6.8 requires a public hearing. You want to, even if you file it tomorrow, we wouldn't have time to get the notice in, I don't think.
Yeah, I don't know. I'd have to talk to McKeel as to what the process would be to amend the existing grading permit for the site, and whether that's something that would require a public hearing or whether that's something that would not
Right.
require a public hearing. If the commission's continues for 2 weeks, or you continue it to your first meeting in February, that would give us enough time to resolve those details. And if McKeel says we need a new special permit application for the grading, we can certainly have that prepared and submitted for the February meeting.
Okay, so we could, is the
I
suggestion?
guess
Yeah.
in a roundabout way, I guess I'd ask the commission to continue it to 2 weeks to your next meeting, and then
Okay.
I will discuss the issue with McKeel, and if it turns out that that we need to submit a new application for the grading, well, I'll ask to have it continued to one of the February meetings.
Okay, that certainly makes sense. But for now, we would just continue it to our next meeting, which is when, McKeel?
January
22nd.
22nd.
January 22nd. Okay. So then we will continue this matter to our January 22nd meeting. Also, like this meeting, it is a Zoom meeting starting at 7 p.m. And usually the same meeting ID and so forth, and it'll be on the agenda. So did you have anything else you wanted to add at this point, Mr. Lee, or you all set?
I'm all set. Thank you.
Okay, so thank you, Mr. Lee. Okay, so this matter is continued to our January 22nd meeting. So thank you very much.
Thank you.
Nothing under old business. Under new business, we have a few items. Item number 1 is we need to set a public hearing. That's 42 Silver Street, and that I think staff will just schedule that for whenever it's convenient. McKeel, is that right? Does that work? Yeah.
Correct.
Okay. And then item number 2 is 21 Acorn Street. That's Al Sicandino, applicant and owner, site plan modification, in addition to enclose the existing canopy and add an additional storage space at 21 Acorn Road. Is the applicant ready to proceed? Looks like Mr. Preddy.
Yeah, that's me. Jim Preddy, Criscolo Engineering, 420 East Main Street in Branford. I will share my screen. So this is the site. It's an existing building. Mr. Secondino's been operating out here for many years. In the rear, Acorn Road is along here. The rear of the building, this section here is actually a roof section with open walls that have been using for storage. But they now, inside the shop here, they now have equipment to make and assemble cabinetry for some of the work that they do. And once the cabinets are made, they really need to be stored in climate controlled areas, not outdoor. So they want to close this in so they can heat it when they need to. And then the other piece of this is this addition here, which would allow them to drive a truck in, load up the equipment, and then drive about. It just gives them a place to, if they could drive the truck in, load it, leave the truck in there overnight, and then drive out in the morning. It's all of this is on existing pavement areas. So we're not really disturbing new. There is a slight expansion of the pavement on the edge here, just to make sure that there's still enough room to get around. There's
Any law enforcement agent, any ICE agent.
There's and I could show you the street view, but there's extensive landscaping and trees and everything that exists here already, and this the whole along the front end. We're not taking down any trees or anything. So it's just some minor pavement expansion, closing in this existing canopy and then adding this basically truck access for loading. I do have also, I mean, for what it's worth, this is what that you won't see this. Nobody will see this except for the neighbors on the backside. But the building will be closed in to match the existing split face block that's there now. I can just to kind of give you a clue. Hopefully, you're seeing the street view.
Yes.
Yeah, okay. So this is the existing building now. I mean, it's hard to see. They have block with banding, and that's what I was trying to show you in the picture. So the new additional match, but you can see the places. Landscaping is really not an issue here. They do have went too far. There is this parking area in front, and I'll go back to the map in a minute here. And this is normally how it looks. I've been in and out of this office countless times, and there's usually not more than one or two cars here. On occasion, because of the cell tower here, and the cell company does have a room in the side of the building here, there may be 3 or 4 trucks here for those guys, but they're only here for a short time and they're gone. So Mr. Secondino typically only has 11 people working in this building, even though the parking counts say that they're, per the regulations say that there should be more. But I'll go back. Here. So this is that parking area in the front that's mostly empty on a regular basis. This is the office staff parks here. If guys need to come get something, they pull in the back and get it out of the storage and they leave. But all the workers on all their construction sites don't come to this building. They go directly to job sites. So we did add a letter to the file stating the number of employees that's normally on here. I bring this up because per the regulations, we're short a few spaces once we add this square footage, but it really not necessary. I did add some potential parallel parking spots, but quite honestly, they won't get used. And that's it. There was a comment from the town engineer about needing WPCA approval. They sent it to their consultant. There's no study is necessary, so all this really needs is a revised sewer agreement. So their attorney, Peter Burdon, will have to just rewrite the sewer agreement and have to get re-signed so that this new square footage gets calculated into the fees. And that's it.
Okay. Thank you, Mr. Preddy. Dan, I think, or McKeel, did you do this one or?
I did.
Okay.
Well, share real quick. Go through it. It is a site plan modification. The building was previously approved. And again, here's sort of a rendering or an aerial. This is the canopied area that's going to be enclosed. You can sort of see the opening here, but it's well landscaped, so you can't really tell that that's open to the elements. But they're not changing the footprint of the building. So it makes it really easy to review the bulk requirements, and it's also existing essentially. But they did change the sort of that outdoor storage now to sort of warehouse. And using that calculation, the parking standard now is changed. There's currently 28 spaces, which was suitable for the 27 required without enclosing that area. But now enclosing it requires an additional 9 spaces. So they were, as a result, they needed additional parking. The applicant has, in their application noted that there's just very little parking need on the site at the current time and for its current use. And I made comments to the applicant to show that it was feasible to get those additional spaces on the site. We have done this in the past in other IG2 areas where we said you need to just demonstrate that it's feasible to accommodate it as a parking reserve, and then it could be implemented when it actually is needed. So I'm recommending that as an option here. It's not a modification. It's just more of a timing. As a reserve, it can be implemented if needed. Again, here's the parking calculations, and went to department comments. No comments from the wetlands, the fire marshal, or the building official. Town engineer did note that the additional square footage requires a WPCA application and approval and a capacity study. Therefore, we did put together findings and conditions subject to compliance. The conditions below, if the commission finds that based on testimony and materials, the proposed modification is consistent with site plan review criteria of section 9.6. The conditions would be obviously erosion controls if needed. That's our standard condition. It might not be needed in this project. Comply with the town engineer's comments regarding the WPCA. Update the site plan to show the 8 additional parking spaces that are feasible as a reserve for future use. This is, I did notice the site plan shared by the applicant tonight does show those additional parking spaces. I don't know if it's been uploaded into OpenGov.
I did, yes.
You did? Okay, so we do have it, so that's good. And then obviously, if there's any exterior lighting changes, I'm assuming they might be putting lighting on the back end of the building. Just making sure that those are compliant with section 6.7 of our lighting regulations. And those are our conditions. I'll stop sharing.
Chuck Candace Chair. Thank you, McKeel. McKeel, and just so I'm clear, I know Mr. Purdy mentioned, a revised sewer agreement will be needed. And is that covered by the condition to comply with the town engineer comments?
It is, and we can elaborate on that if you're ready to make motions tonight. I'll pull it up in the Word document.
Okay, great. And do any commission members have any comments on this application? Anybody? It's fairly straightforward.
Yeah.
Okay. Well, why don't you, McKeel, pull up your resolution?
Okay.
Ms. Brady, do you have anything else you wanted to?
No, I agree. It's pretty straightforward. I mean, it's just a minor expansion of an existing business, so.
Sure. Okay.
All right. I think that addition here should address, at least clarify.
Okay. Sure. No, I think that clarifies that. Okay. Well, I think so. McKeel has presented the draft finding and 4 conditions with slight revision. Does 3? What's this? Update site plan 2 should. I mean, we want to fix that there. To show. Okay. So does as the finding and conditions are presented before us, again, they're similar to what's in the staff report, just updating condition 2. Someone make a motion to approve this application with these findings and 4 conditions.
Chadwick will make that motion.
Motion approved by Joe Chadwick. Is there a second?
Fred Russo will second it.
Second by Fred. Any further discussion? All those in favor, Joe Chadwick,
Joe Chadwick is in favor.
Fred Russo,
Fred Russo in favor.
Joe Vayuzo,
Joe Vayuso in favor.
Marcy,
Marcy's in favor.
and Chair is also in favor. So that application is approved. Thank you, Mr. Preddy.
Thank you.
So moving on then to item number 3. That's Stephen Goldpaper, applicant and owner at 6 Second Ave, a coastal site plan for a single family home. And we're ready to proceed with that one.
Yeah, I'm gonna take that too.
Okie doke.
Jim Preddy again, Criscolo Engineering. Let's go right to the screen. So this is the property at 6 Second Avenue. This is the existing house that's there now. As you can see, I'll zoom in a little bit. You can see it's relatively close to the property line on this side. They would like to do a tear down rebuild, new house. This is the proposed plan where we are moving the house now to be within the setbacks. The house actually gets slightly smaller footprint. They will have to, revise. There's a paver driveway there now. They'll have to expand it a little bit, but we are basically with this new house, basically taking the existing nonconformities for the side setback and the front and making them conforming. We're actually reducing the lot coverage. The floor area does go up a little bit because of expanded upper stories, but it is still well within the maximum floor area ratio. So no variances have been required. So we're really just here for a coastal site plan because of where we are in the district. There is an outdoor shower here, which we've added a dry well for the drainage at the request of the building inspector, I think. There was a comment from the town engineer about stormwater, and there really isn't any requirement to store anything here because total impervious surface is being reduced. But my conversation with him, he did suggest that maybe we could possibly tie in some of the roof drains into this dry well because, quite frankly, when it's raining, you're probably not using the shower anyway. So it would be a good kind of trade-off use there. But other than that, it's a single family home, tear down, rebuild kind of thing that we've done lots of.
Hey, thank you, Mr. Preddy. Dan, did you do the staff report on this one?
I did, and I'll go ahead and share. All right. Okay, all right. Right, we're at 6 Second Avenue. This is just north of Hotchkiss Grove Beach. It's R3 zoning district, but as shown on the site plan, it's an undersized lot, so we apply the R1 bulk requirements as that's the closest to the actual square footage of the site. Let me zoom in a little bit here. As you can see, the red, that's the new layout of the house. They're changing it from non-conforming to conforming with an expansion of the driveway. The orange is kind of the edge of the initial layout, but still a decrease in lot coverage overall with the smaller footprints. It meets all the applicable bulk standards for the R1 zoning district. Parking is not a concern. This is single family. This is just an image of the old structure. This is from this year. As you can see, very close to the property line, but they'll be taking it in. This is a coastal site plan, so we had to refer to the state. We did at the beginning of December. Those 35 days have elapsed, and we did not receive any comments from DEEP, but that is essentially treated as no issues raised from DEEP, so the commission may proceed without any official comments from the state. Staff recommendation, we find the application to be consistent with the Connecticut Coastal Management Act. It's a reduction in the footprint overall. And in our referrals to other departments, no issues raised from inland wetlands or with building official. Jim already mentioned the conversations with the town engineer. And that's further the confirmation that there is a decrease in impervious cover overall has kind of satisfied those comments from the town engineer. We're recommending that the commission approves it, which is the conditions that, erosion control measures shall be installed with an effective date of January 26th. That's all from me.
Thank you, Mr. Rose. Mr. Brody, what was you mentioned in your conversations with the town engineer about the roof drains going to the shower, or what were you? What was
No,
that about?
Jim Preddy again. No, we
Yeah.
we are putting in an underground dry well to handle any, runoff from the shower. If just kind of a new thinking. Typically, it was always just stone under a shower, but
Okay.
so it won't get used a lot, and so just on the which side is this? Hold on. He was just suggesting that at least on the south side of the house that we tie the roof leaders into that dry well just to prevent any puddling or anything. But there really is no storage required. But it will provide infiltration and get some water back into the ground.
Okay. And you're willing to do that?
Yes.
Okay. Is that part of the plan?
It's not shown on there. That was kind of a late
Okay.
adjustment. Didn't make
Could
sense.
you wouldn't have a problem if we have that as a condition?
Not at all.
Okay. So maybe Dan, we can pull up as a condition. That we're tying the roof. Give me the language, Mr. Preddy.
Connect the roof leaders on the south side of the structure to the dry well for the outdoor shower.
South, yeah.
Yeah, south.
Looked like the west south side or the west side.
Yeah, I'm looking at the arrow. It's the south side. The driveway's on the south side.
Yes, alrighty.
And then I think this thing can be effective upon passage. I don't think we need to wait, right? I mean, I know for zoning changes you do, but not for, you have to wait till after it's published, but so I think you can eliminate that.
Make it effective today.
Yeah, or you can just delete it altogether. I mean, so, but yeah.
Okay.
Okay. So then, any comments, questions from commission members?
Marcy, I have a quick question. How does the elevation relate to the floodplain on this? Do they have to lift the first floor up at all from where it's at now, or I didn't hear that in your discussion.
Yeah, the first floor is up at elevation 16. Hold on, I'm looking for the other note. The flood zone is elevation 12. So the garage underneath will have flood ports and actually the whole south side, the complete south side of the house will be above the finished grade, which is FEMA requirement. At least one
So
side.
part of the intent to rebuild is to satisfy getting it above the flood concern.
That's correct. The existing house is not.
And then the overall height of the house is, how much are you increasing it by because of that?
Overall height, from average grade, we're at 34 feet.
Okay. Thank you.
That's only about a 5-foot increase, 6-foot increase.
Okay. I just was curious of what the felt impact might be on the neighborhood based on the height.
Right.
It sounds like it's within the 35-foot limit, so.
Yeah.
Do you have any architectural plans?
Oh, I do. Hold on.
Yeah, I can stop sharing my screen.
Yeah, this is what the house will look like. you know, cedar shingles and
Yeah, nice
cedar
finishes.
shingle, AZEK corner. Um, this is the north side.
Well, really what I like is the relief in the roof line, given that the height change. And the quality materials, it's nice.
And here's the south side with the garage doors that are kind of tucked underneath.
Okay. But yeah, even though it's 3 stories, they've brought that roof line down, so I'm happy to see that.
Agreed.
Mhm.
That's the rear.
Any other questions? Thank you, Marcy. Any other questions from other commission members? Okay, again, it's not a public hearing. I think we may be in a position to act on this one. Unless anyone has any further comments, Mr. Preddy, you have anything else?
I have nothing else.
Okay. Okay, then, if someone want to make a motion to approve the application by adopting the special exception finding and the 2 conditions, as modified in the staff report that Dan is displaying in front of us right now.
Fred Russo will make that motion.
Motion approved by Fred. Is there a second?
Marcio, second.
Second, Marcy. Any further discussion? All those in favor, Joe Chadwick,
Joe Chadwick is in favor.
Fred Russo,
In favor.
Joe Vayuzo,
In favor.
Marcy Palusi,
In favor.
and the chair is also in favor. So that application is approved.
Thank
Thank
you.
you, Mr. Britt.
Have a good night.
Okay.
You as well.
Okie doke. Okay, so next one is item number 4. This is McKeel, Director of Planning and Zoning, I think on behalf of the Planning and Zoning Commission. That's the landscape regulations. McKeel, what's the
Correct.
what's the status
So
of that?
this is, we're receiving the landscape revisions that Peter Henschel and Marcy Lucy and myself have worked on over since we last withdrew them. We're looking to have a public hearing scheduled for February 5th. That'll also give an opportunity to renotice the public hearing with the Planning and Zoning Commission as the applicant, as opposed to McKeel Wackers, town planner. So that will be set. I don't think you would need to take a motion unless you want to, Chair.
Okay, now we'll schedule that for February 5th. I know Joe Chadwick, you made some comments as well. And I'm, I don't know if you guys are still working on it, but hopefully we're looking at all those things. So, okay. So we'll schedule that item. Looks like we'll have a public hearing on that on February 5th. Next item is item number 5, and that's Alexandro De Palma, applicant owner 195 Cherry Hill Extension Lot 11. This is a special exception modification simply to add an in-ground pool. And I believe that they need
To move an
wetlands.
in-ground pool.
Oh,
Yeah.
to move an in-ground pool.
Yes.
And they've got to get wetlands approval. Is that right, Dan?
Yeah, I think
Yeah.
they're at that meeting right now, actually.
Oh, okay. So
There's a question about the modification, whether you want to have a public hearing.
okay, right. The question is, do we need to have a public hearing on this? The reason why it comes up is because even though this is a subdivision and people, we don't typically consider changes in lots. If someone could put a pool on a subdivision on a single family lot, not show up in front of us. But this was part of a special exception for an open space subdivision. And since it's changing the layout of the approved special exception open space subdivision, they need to modify the special exception, but we have authority to waive the public hearing if we consider it minor, which frankly, I think it is. It's just changing a location of a pool, which normally we wouldn't even consider. That said, because it's part of this, the way it was set up, the whole thing was an open space subdivision. I think that's why we're dealing with it. So do we have a does someone make a motion to waive the public hearing, or before we make the motion, do people agree with me? Does people have any questions about that? Is it okay to waive the public hearing? Maybe I'll just go around. Joe Chadwick, what about you? Do you think we should waive the public hearing for this?
Yeah, I could go along with that pretty easily. I'm not sure what we can contribute to the discussion.
Right. Fred?
I agree. I mean, if they're going to put a pool in for the first time, maybe we should be concerned, but they already have one there. Moving it to the left or the right or forward or backward doesn't seem to be a big deal. So I'd say we should waive the public hearing.
Okay, thanks, Fred. Joe Vayuzo?
Yeah, definitely waive. Like Fred said, this pool is already there, and just moving it. They're not adding up a pool, so definitely doesn't need to require a public hearing, in my opinion.
Right. Okay. Marcy?
Well, I'm 3 for the yes, so I'm just going to agree.
Okay.
I don't really know the site, so it's hard to. It doesn't seem like a big deal.
Yeah. Okay. Okay, then I'll make, just want to make a motion to waive the public hearing for item number 5, 195 Cherry Hill Extension, special exception modification to move the location of the pool.
Chadwick makes that motion.
Motion by Joe Chadwick to waive the public hearing. Is there a second?
Fred Russo will second that.
Second by Fred. Any further discussion? All those in favor, Joe Chadwick?
Joe Chadwick is in favor.
Fred Russo?
Fred Russo's in favor.
Joe Vayuzo?
Joe Vayuso in favor.
Marcy?
Marcy's in favor.
And chair's also in favor. Okay, so we'll waive the public hearing on that. Wait till we get the wetlands decision, and then we can act on that one. Next item on our agenda is our minutes. I think they were sent out in the packet, although I didn't see them on the emails, but I did receive them in the packet. And I don't know if everyone had a chance to review them. If so, someone have any comments or want to make any motion, or did everyone receive them? I guess I should start with that. Has people received the minutes from the December 18th meeting?
Yes.
Okay. I mean, I got them. They were in the packet I received, but
Yes.
I just don't remember. Okay. Okay. Then someone make a motion to, with respect to the Thursday, December 18th, 2025 meetings.
Fred Russo will make that motion.
Fred makes a motion to approve the minutes for the December 18th, 2025 meeting. Is there a second?
Chadwick seconds.
Second, Joe Chadwick. Any further discussion? All those in favor, Joe Chadwick?
Joe Chadwick is in favor.
Fred Russo?
In favor.
Joe Vayuzo?
Joe in favor.
Marcy?
In favor.
And chair's also in favor. Next item is correspondence. Is there any correspondence?
No correspondence.
Okay. And then other business, planners report. What's going on, Nikhil?
Yeah, I want to share real quick, give you an update of where we are with our planning initiatives. So just to refresh, we have right now 8 planning initiatives that we are actively working on. So they're coastal management, open space strategy, transit-oriented development, form-based zoning, infill development, and redevelopment, housing, as well as proactive code enforcement, and then town center. Give you a sense of where we are. This is the timeline we're working on. There's been some minor changes in the timeline for housing. Some of that has been brought up a little bit, but mostly do some internal work. And we're looking probably in February or March to go do external stakeholder outreach. Form-based zoning, we presented to you last night. We presented to Stony Creek Architectural Review Board. And Dan is also starting to do stakeholder outreach beyond that. That'll go on probably through February, at which point we might give you an update of what Dan has collected before we sort of dive into some more substantive policy work. Transit-oriented development. You might hear at some point about a resolution going to RTM. It's about an opt-in to become a member with the Connecticut Municipal Development Authority. It's a new authority. It's quasi-public, but it is tied in with transit-oriented development and sort of the housing policies that the state is doing. and they're going to provide some technical assistance down the road, potentially financial tools to help us in this space, but obviously that's much farther down the road. And our GIS consultants, Tyche Consulting, they're actively working on the coastal management and the open space strategy. And then Jamie, Frederick, and Dan are starting to do the stakeholder outreach on coastal management and open space strategy as well. So all of that is moving along. Just to refresh you with what the colors are, this is the process from left to right. So we start with data collection and GIS work, go into stakeholder outreach. Then we start to take that information and sort of work through what policy recommendations and potential regulations might come out of that. After that, we'll bring it back and start probably a focus group feedback, which could take form in community meetings or even maybe in front of the Planning and Zoning Commission, whichever form makes sense. And then formally, we'll do some sort of adoption process before whatever committee or agency makes the most sense to for that to happen. And just to reiterate, this is sort of visually where we are, what's underway, what's completed. And as time moves on, you'll see that we get closer to the red, and you will have a role to play. But I wanted to make sure you're aware that things are actively in progress. Happy to answer any questions on those initiatives before the second item I have to share. No questions, that's fine. In our conversation with Stony Creek last night, the Architectural Review Board, obviously a village district was established in, I believe, in 2015. And then a couple of years ago, they expanded their scope of what projects they review. Last night, they asked me to get the pulse on the Planning and Zoning Commission on whether or not you'd be open to entertaining expanding it further to something more akin to what the Town Center Village District does. And I said I would at least have the conversation with you in the planner's report. And I'm really here I don't have a position. I think their feeling is that there's so little activity. That is a rationale for wanting to make sure that they are utilized to the extent feasible in their jurisdiction. I did share this with the chair, so we had a conversation. And I think he has some good insight. And I'll hand it over to him.
In our pre-application meeting earlier today, because we typically do is run through the agenda with McKeel before the meeting, he raised this, and my reaction was the whole this emerged of what the Stony Creek Architectural Review Board does. It was somewhat of a compromise. I mean, what I remember is the facility was done by the Stony Creek Association, the original proposal, and they had internal meetings, and the whole idea, the general notion is how much should you really regulate? Because it's largely, I think, single family dwellings. It's largely just houses. There is a commercial part, a small commercial part, but not a whole lot. Largely it's residential, maybe a few barns and things like that. And the question is, how much do you want a regulatory body, Planning and Zoning Commission, with reviewing that, and how much do you want an architectural review board doing that? And the pros and cons, the pros are, yes, this is a special part of our town. This is a community. This is, we take great pride in the way our houses look, and there's, we don't want someone out of town or coming in and putting up some monstrosity. So yeah, we should be regulating parts of those things. That's sort of one side. I'm sort of caricaturizing a little bit. And the other side is no, single family dwelling, that's really the property owner. I should have the right. You shouldn't even be regulating at all. You don't regulate other parts of town. Why should you regulate us? Okay. So anyway, those were kind of the battles that were going on before the thing even got started. I remember, sitting on the commission, and the way it got resolved, essentially, I mean, in my mind, was that the the Stony Creek Association sort of, took a whole canvas of their community. There was a vote, and there was a majority, and there's still some people that are opposed to it, but this is what they ultimately agreed to, a sort of self-regulation of particular things, even though there was some opposition. I mean, there was a former member of the board that Joe Bioza remembered, Phil Fisher. I remember him coming saying, "No, don't get it. Don't tell me what I do in my house, whatever." But what sold me was that no, this is what you're choosing into. This is what you buy Stony Creek. You're part of this. This is what the community involves. So whatever. So my whole thought was that if you want to alter what it is, the scope of regulation, that's where you start. You start with your local Stony Creek Association and community, and that if you think there's a broader range that you think your town, your area of town, your village is going to support, then start there. And then make some modifications and come, and we can look at it and have a broader public hearing to that. That's kind of where you go. I didn't know if there was, because I didn't know if there were a lot of approvals going on that they were saying, oh, well, you approved, something happened and it didn't come before us and should have come before us. And I understood from McKeel that they weren't even saying that. Their complaint was, hey, we're just not doing much. And I don't know if that's a function of maybe there's just not a lot of development going on there. So those were my reactions when I heard that. So, but if it's simply the fact that, and they're volunteers, they add expertise, and I love all that stuff. We're in the same boat, and they provide that, and I buy into all of that. But if it's simply that there's not much going on, then okay, there's not much going on. But if there's some specific element that they want to increase for more regulation, then start locally, bring it up, and come up with some possible modifications that we could consider. That was my reaction. But I don't know if others have reactions, want to go around. Joe Chadwick, you have any thoughts?
I am one who tends to stay on the less regulation is better regulation. However, in this case, I'd be really interested to see if there was some sort of referendum that would find some commonality among the Stony Creek residents to increase the scope of the design review. It's a really, really architecturally intact area, and it would be nice to keep it that way. And I would also further note that they had gone to the trouble of getting Bob Orr to draft out some design standards. And those design standards got a Connecticut Historical Society award that year. I think they are probably a good groundwork for form-based zoning. And I would be really interested to see if this thing has legs within the Stony Creek community. But I would not want to impose anything. I would rather see the will for it generated within the community.
Great. Thanks, Joe. Fred?
Well, it's kind of interesting. The very first time I ever voted on anything when I was on the commission, I didn't vote as a commissioner. I voted as an alternate because John Lust, who was the commissioner at the time, was not at the meeting, and Mac McGuigan asked me if I would vote. Never did it before, wasn't very familiar with what was going on. And the vote came up about whether or not there should be a design review board. And I was, my opinion was I didn't know much about Stony Creek, really one way or the other. I didn't have any personal opinions either way, but I was always I'm still the guy, I'm not for over-regulating. I think when you over-regulate, I agree with Joe, when you start over-regulating, we're not doing our job. I think that, there are property rights. And if I recall at the time, the motivation was because there was going to be a house that was going to be built out of design. It was going to be a contemporary style house. I think that's what motivated it to begin with. And I give the people in Stony Creek lots of credit. They did an unbelievable job in making a presentation, probably to their own members, but especially to the commission. And I recall that the vote was 4-1 in favor. I was the one who opposed it. And I would still oppose over-regulating. I agree with you, Chuck, in that it's got to be organic. If the people really, really want it, then they should get what they want, assuming it's reasonable and it's within our regulations. But so I'm not against that at all. But I think we have to be careful. There are other people in Stony Creek, beside those that live in that village area, that may not agree. And I think that we have to be, it's just like we had a conversation about what should the height of houses be down the water, should they be higher? And I think we kind of all agreed one way or the other is that, we have to have regulations that are uniform. If you've got the advantage of viewing the water, do you need to have 40 feet instead of 35 feet? It just seems crazy. So I'm of the opinion that if they want to do it organically, that's fine. I think just for us to be the bad guys and start imposing rules and regulations and things that maybe you're not fitting, because if you do it for one, you have to do it for others, or if you do it for one and you don't do it for others, it just doesn't seem right to me. So I think that when we have an opportunity not to do something, not being negligent now, but not to do something that's going to create its own problems, we should be very aware of that. So that's what I would say. I still believe that no regulations, but I think good regulations are important. But just because there's an outcry because a particular incident happens in your neighborhood, you have to have rules and regulations that punish people in the end. And I'm not for doing that. I believe that property owners, I think, and I'll just go a little bit further. I think the case I made was, I said when I took a ride through Stony Creek way back then, I said, I noticed that there were 3 or 4 mansions there, Victorian style houses. They do not fit the neighborhood whatsoever. Okay. And yet today, and that was back in 2011 or 12, whenever it was, I said, who in this room, I was talking to people from Stony Creek, would want those mansions ripped down and build little colonials? No one would. I said, neighborhoods evolve, and I'm not against keeping it in a certain style, but I don't know where those mansions fit in. They don't, those Victorian style mansions, there's 3 or 4 of them there. They don't fit anywhere, but I don't think anybody would want to see them go. So I think as times change, people's opinions change, and if they want to change it, it should be done organically. That's my opinion. Thank you.
Thanks, Fred. Joe Gaiuso?
Yeah. Well, it's all coming to mind now because pretty much all the arguments that we're talking about now were done back then as well. But I think there was a compromise made. That's why the arguments were going back and forth, and like Fred was saying, back and forth, who has the right, who to do this, who doesn't have the right. But I thought there was a compromise made on them having jurisdiction on a home of a certain amount of square feet, a larger home. And just like Fred was just saying about those larger Victorian style houses, if I remember correctly, they were more or less concerned about big projects, people that are buying 2 and 3, 4 lots, and then combining it as one and putting up some big house that doesn't fit with the character of the neighborhood. And I think I'm almost positive that their jurisdiction started with a certain amount of square foot of house before they had jurisdiction, like 4,000 square foot house, something on the larger side, and that's when they wanted to step in. Not so much a quarter or half acre lot with an average size house. I think that's what it was. Something that they have jurisdiction now over a much larger house where they take over 2 or 3 lots and then put up something that doesn't even look like the neighborhood. That's what I'm kind of remembering.
Joe, I think there's threshold of what comes in, one's out, and there was that was debated, and they came up with some numbers, and I think it was changed as to what's the threshold that you got to go before the board. How big does the project have to be? But I don't know. Yeah, I think that, yeah, and I think that's in the regs now. But I guess, you know, McKeel's been asked, hey, we'd like to look at more applications. And you've heard the response. The response so far is, okay, well, you know, get your community. Is that the sense of the community? You know, because there's pros and cons of how much you want to reg. So I didn't know, you know, and you were around as I was and Fred was and you know at that time too. So and Joe was I think too and
Marcy was.
Marcy. We were probably all here because we're all
Yes.
old, right? So yeah, so
Think for yourself.
right, right. So it it Joe Viosi, do you have any other thoughts or
No,
you
no,
know
that's all I thought. It's just like deja vu all over again. The arguments are being mentioned again the same way, the basic
okay,
same way. Yeah.
sure,
No, you're right. You were right about that.
okay.
So I'm good.
Thanks, Joe. Marcy, any thoughts?
Yeah, so back then when we were considering all that, I didn't live in Stony Creek, and now that I do, and I have lived in a number of areas around town, and I can personally attest to the fact that there are a number of artists and architects in the area, specific into Stony Creek, who want to be involved, compare about the visual aesthetic, compare about the care about the massing and all the things we discussed relative to the what size should we be, reviewing way back when in terms of form-based zoning and all that. But what I can offer, as a resident, in comparison to living in other parts of town and having lived in this town for over 35 years and being married to someone who's lived here longer, the Stony Creek community is a very, very engaged community. We get, lots of emails, lots of notifications. There's lots of, um, really involvement in terms of reaching out to inform everybody about what's going on. So, I think it's a situation where, perhaps this is, something that the community wants to have a little bit more control over their future look as the pressures for, it's an area that in the summer is, a very high traffic tourist area where it's constantly being um, singled out as a tourist destination more so than other parts of Branford. And, I think with that comes a different standard of care for protecting both the history and, protecting the future outcome of what it grows into being. Obviously things happen. We just had a terrible fire on an older house over on Thimble Creek Road, and that's going to be a new structure. So things happen, and there's sales that happen, people come and go, and but there's still, I find, a number of residents who have been here for a very long time, who've lived in my house and whatnot, and there's just a lot of pride and care for the community. So, if this is something that we want to test in the town, I mean, this to me is the place to do it. And if there is, the consensus among the community and the commitment among the community to, set up a review board, it's still only an advisory thing. It's not, it's not, I think it will only serve to inform us as a commission, their opinions, if it's something that later has to come before the commission. So I'm really not opposed to letting them run with it and see where it goes.
Yeah, the board already exists, and the question is, should they be reviewing more stuff? Because that was my understanding from McKeel, because they're saying, hey, we don't seem to be doing much. And my
Yeah,
questions was, well, it could be because maybe not much going on, or maybe you want to enlarge a jurisdiction. And sort of the sense was, and Marcy, you're from this. I didn't know you lived in Stony Creek, Marcy. So we
Yeah,
find out more stuff all the
I'm
time.
just upbridge. There's a
That's right.
there's a very strong distinction between upbridge and downbridge,
Okay.
and it's, yeah, and I'm in one of the old quarrymen's houses that
All right.
was in foreclosure that, we tried to build, and, I didn't have to go before the board, but the addition to make it work and to make it a combined property did have to go before the commission, and that all happened before I ever realized I was going to end up here. You know, life kind of happens as it happens. But you know, but yeah, I mean, it's a very eclectic, interesting community. You know, very, you know, very artistic, very, you know, open. You know, they have the farmers market every weekend, which has been a huge draw. They do, you know, there's just a lot of community activities that I've seen that aren't happening or happening to a lesser extent, maybe in other neighborhoods. You know, and it's really, I feel like the last dying breed of a neighborhood in some respects, you know, being around here, which is, you know, it's been a great experience. So.
Let me get everyone in. Sharon, do you have any thoughts?
Yeah, I sort of am agreeing with Marcy. I really think that Stony Creek is very unique and that the community there is very involved in what's going on. And I would like to see them retain some measure of, you know, have them have some ability to have an opinion. As Marcy said, they're not regulatory, they're just advisory. So I think they should be able to have a say in what their community looks like. And as Mikhail keeps on reminding us, everybody he's talked to has always said, we want Branford to stay looking like Branford. So I think that would also go along with that philosophy, as well as some of this form-based zoning that we may be considering in the future. So I think it's a good idea, but I would also like to hear what it is that they would like more jurisdiction over. I would really like to get some more specific information about what it is that they're asking for.
Yeah.
Okay. Yeah. Okay. So my sense is number one, there's a universal recognition among the commission members of the uniqueness of the place, the dedication of the town, the involvement, the artist community, the village nature of it, the quality of the architecture. Joe Chadwick pointed out the work that they went in to do that. So all that is great, and we affirm that. The question seems to be, okay, so what is it that you want to change? What would you like it differently? And the other theme was, and you probably should start locally. In other words, and that's why I mentioned the association, because I don't know, there's a Stony Creek Association. Where I live, there is no association. I mean, that's an indicative of part of the quality of the place, that they have their own association. They have a process to, hash out ideas or whatever, and then maybe get something through them, come up with some specific proposals. We want to enlarge our jurisdiction so that we do, the review board does consider these things that it doesn't now because it doesn't meet the threshold or whatever. And then we could do that. And then there's the whole, I thought it was a separate question. The form-based zoning was sort of a separate question from that, although maybe that is, it may intersect later on, but I wouldn't put them together. So anyway, that's my general understanding. Mikhail, does that give you enough of?
No, this is a really helpful discussion. I think it gives them a path that they should work on. And I think it respects also this history of how decisions have been made regarding regulation in the village district. So I'll circle back with them and let them know. I think the two things that really is driving this conversation is, one, they feel like they're not doing enough activity, which is really driven by permits and not by your existence. And two, they compare themselves to the town center, and the town center has a much broader scope of, if it's a site plan or if it's a special exception, it requires the review. Whereas Stony Creek, it's if you're 2,000 square feet or over, then you require a review. And most properties actually fall below that.
Yeah, and the town center is a lot more commercial, non-residential stuff that our changes are by site plans. So that is, right, or by special exception, and that just doesn't exist down there.
Mm-hmm. Chuck, Fred Russo.
Right.
One last point. I think it's kind of interesting. It would be interesting to see if the people at Stony Creek feel that they're not as engaged with what's going on. It would be interesting to see how many applications have come through the planning and zoning office to begin with. Maybe there's not many coming through from Stony Creek to begin with, So therefore, there's a much lower demand for their involvement. It's not because people don't want to be involved, that the regulations are wrong. Maybe there's just not a lot of work. I mean, I'm just thinking on our own part as on the commission. I don't recall many things coming through. I'd be surprised if it was 10% of the stuff that we get to hear. And I'm wondering, is there concern about not being involved enough based on, there's a sense of being excluded in some way by regulation or whatever, or is it just because the people of Stony Creek are not as active in looking for taking permits to renovate the house? They leave them pretty much the way they are. So that might have there may be some validity in finding out, how many applications come from Stony Creek to begin with. Maybe there's not a lot, and that may account for why there's not as much activity going through their commission. There's no question that more goes on in the town center because there's more buildings, there's more people, there's more businesses. That's not an apples to apples comparison to what is in Stony Creek. So it would be interesting to know how much activity does our planning and zoning commission get and planning office get just to begin with from Stony Creek. Maybe it's not that high to begin with, and therefore that's why they don't get to see as much as they maybe think they should, unless things are going on behind their back that we don't know about. But I don't think that's the case. I think people in Stony Creek are pretty vigilant. They watch what goes on, and if there's a problem, they're going to report it. So I'm just thinking that maybe there's not a lot of stuff coming out of Stony Creek to begin with. That's why they don't have as many reviews that they would want. But that's just a thought.
Yeah, there's just not a lot of applications.
They're not, right?
No.
No, I didn't think so.
I think. Go
Fred?
by you so for a sec. I think
Joe.
the crux of what they're saying is it's not so much. I think of the fear of something happening that they had no control over because there was no regulation. So that's why they were talking about having some review board to try to prevent something that might happen that unforeseen. And if it did, then there was no regulations to back them up. And then that person doing whatever that they were in disagreement with was capable of doing it because there was no legal consequences. So I think that's where it started from. Because I think one or two properties were put together and put a couple of big houses, and people started saying, well, now you got to start changing the neighborhood, changing the area, and it came from fear of what might happen in the future. So that's where I think it started. But that's my opinion right now. That's all. Thank you.
Thanks, Joe.
If I can jump in once more, I think a lot of this may be evolving out of our jurisdiction, if you will, because the vector I'm seeing is they are looking for the authority of a commission as opposed to an advisory board, and they want to be on the path of approval for a building permit. Maybe they didn't say it, but this is kind of like what I'm sort of sensing. I have done work in many towns that have had historical commissions that had that were enabled to be in the path of a building permit, and you had to go through the historic district commission in order to get your ticket stamped, your drawing stamped to take it to the building official. And in the current situation, they are advisory to planning and zoning. If they want to be busier, they need to have some force and effect that doesn't really exist. I mean, they can be a bunch of great guys that you stop by and say hello to, show them your plans, chat about it, have coffee and maybe a beer, and then, you go do what you're going to do anyway. But they may be looking to have some force and effect over the built environment in Stony Creek. And at that point, we're just standing on the side saying, go for it or don't go for it. But we have no authority in that process unless there's an actual zoning change.
Thanks, Joe. Yeah, and if they want to propose a zoning change, then get the majority of the community to come up with something and that they think the community wants. And
Yeah,
yeah.
well, it's basically the difference between what does this group of reviewers want to accomplish and what do they want for their authority and how do they want to exercise their authority, and how does that relate to the community and ultimately to zoning.
Okay, McKeel, you got enough?
I do.
Okay.
Thank you.
Great. Anything else under your planners report?
That's it.
Okie doke. Okay, and I think the other things listed on the agenda are just the pending items where looks like we're waiting for deep comments, right?
Correct.
Okay. So I think that's it. Does anything have anything else? If not, then someone will make a motion to adjourn.
Fred Russo will make that motion.
Motion to adjourn by Fred. Is there a second?
Chadwick seconds.
Second by Joe Chadwick. Any further discussion? All in favor? Joe Chadwick?
Joe Chadwick is in favor.
Fred Russo?
Fred Russo's in favor.
Joe Vayuso?
Joe Vayuso in favor.
Marcy?
Marcy's in favor.
And Chair is also in favor. Thank you, everyone.
Have a good
night.
night, everybody.
Good night.
Have a good one. Thanks.
This program was brought to you in part through the support of the Town of Branford. Watch town meetings and other videos on demand at BranfordTV.org.